Mr McKeown and to his officials. I just want to have a few questions around the public service card. First, Mr McKeown, I want to put, you might recall, or you might be aware, we had the Data Commissioner before us a number of weeks ago, and we put questions to her on this issue as well. But just in terms of her report, she published a report a number of months ago and in fact made a number of directions to your department on foot of that report. And there was 3 high-level findings in her report. The first is that there was no lawful basis on which the department can rely to Safe 2 register and issue PSCs to persons required to obtain a PSC in order to transact with a public body other than the department. That was the first high-level finding from her investigation. Do you accept that finding?
I think we're on the record of saying we don't, Deputy, no.
Okay, don't accept that finding. The second one was that the department has not complied with the data retention principle insofar as that it keeps all documentation relating to safe registration for longer than necessary. Do you accept that finding?
No, we do not.
Not that one either. And the department has not delivered sufficient transparency to the public in terms of what personal data it processes in the context of the Safe 2 PSE. Did you accept that finding?
No, Deputy, we do not.
So three high-level findings from an independent individual who has statutory powers, who has a responsibility to ensure that the rights of citizens are protected, does a very lengthy investigation, and the department doesn't accept any of the 3 high-level findings from her investigation.
Well, there were 4 findings, Deputy. The first one was that the department...
I'm reading from her report, so I'll put what's from the report first.
I think it's important to say...
Bear with me. I'll put what's in the report. So page 10 of the report, it talks about 3 high-level findings. There may be more. There are many other things that she talks about. But there are 3 high-level findings which I've just put to you. And all I want is, and you've accepted it, the department doesn't accept any of the 3 findings.
No, and there are obviously reasons for that. It's not a decision the department takes lightly. We take it on strong advice of the Attorney-General. The public service card, I think, delivers a lot of benefits to administration and the customer service. It would be, I think, reckless and foolhardy if we were, on the basis of the advice we've received, not to challenge those findings.
Yes, but and you can put up a defence, and you're entitled to put up a defence, absolutely. But I just wanted, first of all, on the record, so there's no dispute, that the main 3 findings of her investigation, of her office's investigation, the department doesn't accept.
Sorry, there are 4 main findings, Deputy, and it's important to say the first finding was that the department is perfectly entitled to register people and issue public service cards and ask for them to be produced when in the context of the department's own services. Can
I just read from her report, because there may be others? So I'm reading from her own report. I'm putting questions to you in relation to the Data Commissioner's report. So page 10, high-level findings of this in this investigation. 3 key findings of this investigation are, doesn't mention 4, mentions 3. There may well be others, but I'm saying from the Data Commissioner's report, she cites 3
Is that the September
findings. Yes, same one. Yeah.
The September report.
Yeah.
Department summary. Oh no, that's your
response. No, sorry, her own. This is her report. Her report.
Response, yeah.
In any event, I'll move on because I wanted to just look at process. And what's important here is, and it was quite an interesting discussion we had with the Data Commissioner in relation to the interaction between the Office of the Data Commissioner and your department. And the Data Commissioner had some stuff to say in relation to that, which I'll get to. I have extracts from what she said. And there was a number of issues in relation to that interaction. And on page 12 of her report, she talks about the department was not in a position to meet a deadline that was set on the 31st of October 2018 to a draft report, I think it was, and stated that the department intended to send its response to the DPC by the 30th of November, and I think at that point it threatened legal proceedings or the possibility of legal proceedings. Is that correct?
Yeah, I think it's unfair to call it a threat, Deputy. I think the context there, and I think this is important to say, is we got the report from the Data Protection Commissioner, the draft report, which ran to a number of hundred of pages at the end of August 2018. We were asked to respond in a period of about 4 weeks. Obviously, we had to consult with the Attorney-General's office. We had to consult with the Department of Public Expenditure and Reform. It simply wasn't possible to meet that deadline, and we indicated that we needed a period of 3 months to do so. The Data Protection Commissioner responded to say, listen, we don't really accept that you need more time than 4 weeks, but we'll give you 8 weeks. So in that situation, we had to reply and say, listen, we really do need the 3 months, and we are entitled to due process, and we will, if necessary, take steps to ensure that we
But
get
I think
due process.
her point was that there was a number of extensions that were given, and this was another extension that was sought, and again was given.
No, I think that's. We did look for one extension to the end of November. As I said, the Data Protection Commissioner said, well, we give you 4 weeks, another 4 weeks, another month, rather than the extra 2 months we sought. So we did respond and say, listen, we really do need the 3 months.
She says in her report, I'll read directly from her report, that on the 26th of October 2018, her office responded agreeing to one further extension and stating that the threat of legal proceedings, and she used the word threat, not me, the threat of legal proceedings was unwarranted in circumstances where the DPC had already provided an extension of a month.
Yeah, that's exactly what I've just said. The DPC, so I don't think there's any difference between us.
There was a number of extensions.
No, well, the DPC gave us one extension of 4 weeks. And then after we wrote in and said, listen, we really need an extra one, and we're reserving the right, if we don't get it, to look for due process, then she gave us the extension.
Yeah, and I'm interested in that due process, and I'm interested in what was the relationship between your office and her office at the time, what interaction was going on, to give us an understanding of how departments interact with what is a statutory office as well. And then the response was sent on the 30th of November 2018, and she says in her report that 470 scanned pages, which were unpaginated, which I believe is unnumbered, or not numbered, is that correct?
That's correct.
Were then sent with 28 appendices.
Yeah.
Who sent that?
The department did.
Who?
The department did. It was our.
Who in the department?
It was our data protection unit. And I think Deputy.
Who was looking after? Who in the department was looking after?
Sorry, I want to deal with the first issue, Deputy, first, if I may. We, in our letter of the 30th of November, including that document, and we published this correspondence, we explained precisely why the document was unpaginated. The Data Protection Commissioner had sent us, I think it was 14 findings and 17 requests for further information. In order to respond to those 14 findings and 17 requests for further information, we had to insert in the document a lot of exhibits, a lot of technical specifications and so on, which were scanned documents. They weren't our documents, they were technical documents. That meant that they were being scanned in with page numbers already on them, which meant that the numbering sequence when we paginated it didn't make sense. So, for example, our text, which was 151 pages out of the 400-odd page
Mr.
document.
McKeown,
just let me explain this.
No, I want to stop you there for a second.
I think this is important, Deputy, because you're suggesting something that we're trying to be difficult.
With respect, I'm putting the questions. So, if I can come back in and say this. If we, as a committee, sought a report or sought information from a department and we got 480 scanned pages unpaginated, I'm sure we would return it. Now, what she said when this was put to her was that this was unusual and, in fact, far from the norm when getting information back from a department. In fact, she was quite critical of your department for the manner in which it was sent back.
I think, Deputy, the important issue here is
the important issue
I'll explain it, because you're saying that it's unusual.
Through the Chair, I'm going to let you back in. The important issue is that there is good and healthy exchanges between government departments and statutory agencies, and that there is appropriate ways in which there are responses given to very serious issues. She had a draft report. She was looking for responses back from your office, and it was sent by way of 470 scanned pages, unpaginated, and subsequently she got what she said was a searchable version, but it took some time to get it.
So
that's what she's saying.
If you allow me to say what I need to say, I'd be grateful, Chair, if I could, because you're suggesting, I think, Deputy, that we are trying to be difficult or obstructionist. That is far from the case.
I'm not suggesting that. That's what jumps from the report.
Well, it jumps or suggests, Deputy. I think you'll find that you talk to any other body that has done any reports, including, I think, the Controller and Auditor General, including the Ombudsman's Office. The department bends over backwards to facilitate inspectors and auditors. We bend over backwards to give cooperation and to give support. And we generally, even in reports which have been critical of us, as a number of Ombudsman reports have been, they always compliment the department and the cooperation given without fail. In this case, the reason we did it was to try to be helpful.
Well, Mr.
And let me explain why.
If
I can, Chair, if I can finish my point.
Talk to me.
If I can finish my point. The point is that when you put exhibits into a document and then you paginate them, we would have had pages 1 to 10 of our document. we'd then put in an exhibit which itself was paged maybe 20 to 25. Then it would go back to page 11 of our document. It just didn't make sense.
But
what we did...
Sorry, through the Chair, if I can just... Can I just ask that? No, hang on a second.
No, I need to
sorry,
finish.
through the Chair.
I don't
this
think
is my
the Deputy
time.
wants to hear the answer.
No, I do want to hear the answer.
Well, then let me give it.
And I'll let you give the answer in a second, but I won't be bullied, and I won't be not allowed to be put in a position to put questions to you. So it's my time. And I'm putting the questions to you, and if I feel I'm not getting the answers, I will ask you to stop, because I want to put further questions to you or clarify what you said.
The answer,
you are entitled to, but you weren't answering. In my view, I listened to what you said, but it's not an acceptable answer. Now,
well, you didn't get the answer, Deputy, because you kept interrupting me.
No, I didn't. I let you go for a full minute, and I didn't hear anything that was acceptable to me.
Deputy, the reason we did it was that pagination didn't make sense when you included exhibits. So what we did for document navigation, we numbered every single paragraph in the document to support document navigation. And the reason it was scanned is because we had to scan in documents which are not documents of our authorship into the document. When the DPC came back a number of weeks later and said, can you please paginate anyway, and can you please give us a document that's searchable, we turned it around in a day or two. We were not being difficult. We were trying to be helpful by numbering every paragraph for navigation purposes rather than every page, because the pagination made the document unnavigable.
I think it's fair to say you got fair wind in the response. That's not the opinion of the Data Commission.
Well, that's fine.
And it's also, and we're entitled to give our own views as individuals. It's also not my view either. I don't think that was a reasonable way to respond. And I want to come back to.
Reasonable.
Well, I don't.
Just making it clear, so the witnesses understand. A person who draws a conclusion, that's the person's own. It's not the view of the committee. The committee will have a view in due course.
And more importantly, in this case, because I can have my opinion, the Data Commissioner also has her opinion. There was also a parliamentary question that came back on this issue, which I put to the Data Commissioner, and I want to put it to you as well, Mr McKeown. It says the Department sought to meet the DPC on 2 occasions since receipt of the report, with a view to outlining the basis for its conclusions and seeking to clarify a number of matters of concern relating to inconsistencies both within the DPC's report and between the report and accompanying letter from the DPC. The request for a meeting was declined on both occasions, and then the Data Commissioner talks about a number of media appearances that were made by the Minister as well. On behalf of the Department, it should be said that essentially the point was that the Data Commissioner refused to meet with the Department on 2 occasions. So can you explain to me what happened there from your perspective?
Sorry. We got the Data Protection Commissioner's report, Deputy. The Data Protection Commissioner asked us to take a certain number of steps, some within 1 week, some within 3 weeks, some within 6 weeks. Jackie McCrum, who's the Deputy Secretary here, wrote at the end of the first week and said, can we have an early meeting with you to discuss these things? And the Data Protection Commissioner replied saying, well, we'll meet with you once you give us the full details that we're looking for at the end of 6 weeks, but wasn't prepared to meet with us then at that point in time. So that left us in a situation where we had to prepare our information.
She wasn't prepared to meet when? Sorry, because that's very important.
At the end of the she'd given us 6 weeks to produce a very detailed implementation plan.
What date were you saying that she wasn't prepared to meet?
That was, I think, the 22nd of August.
The report was delivered on the 15th of August, and this request went to her on the 22nd of August, and she replied on the 22nd of August to say that she wasn't prepared to meet.
She wasn't?
That's correct.
Okay, so
until such time as we had prepared our plans in accordance with her letter, which would have been at least 6 to 8 weeks later.
Can I just read from her evidence that she gave to this committee? Because what you've just said there is that she wasn't prepared to meet.
She wasn't prepared to meet until we had prepared our plans, but we needed to speak to her deputy before we made our plans.
Let's read from what she said, because I find the Department's response even to these questions very defensive, which is fine. But it shows that it was the same sort of approach that was taken with the Data Commissioner, and the same approach that's, I would argue, taken in a number of other areas I'll get to in a second when the Department deals with individuals and organisations. So what Ms Dixon said was that, and I quote, that she had indicated in her first response that she was prepared to meet, that she responded to a letter from Ms McCrum, which is yourself, on the 22nd of August, indicating in the affirmative that I was willing to meet and that a meeting could indeed be useful once the Department had tabled the implementation plan, which she was entitled to do. In my view, she was saying, yes, of course I'll meet, but there needs to be an implementation plan, which she says I directed in the letter of the 15th of August. She then says, in fact, Deputy Cullinane received from the correspondence on the 22nd of August that was open to meeting once that implementation plan was tabled. I did not hear anything further about a meeting until correspondence on the 3rd of September from yourself, Mr McKeown.
That's right. I think
so why then was the offer not taken up? Because the implementation plan wasn't put in place.
No, sorry. I think, listen, I mean, and you can try you can try to present this whatever way you wish, but it's a very simple professional process of an exchange of correspondence. That's all it is. We sought an early meeting. That was our letter to the DPC on the 22nd of August. We sought an early meeting. The DPC came back and said, listen, for its own reasons, it wasn't prepared to meet with us until we'd submitted the implementation plan, which was to be October. So we sought an early meeting and we didn't get acceptance of an early meeting. That's the point we're making. We then had to consult with the Attorney General's office and with others. We determined what the appropriate response was, and at that point we then wrote to the Data Protection Commissioner advising the Data Protection Commission of our response and saying, listen, we'd still like to meet. I don't think there's anything untoward or difficult about that. There's nothing contentious in it. It's simply an exchange, a professional exchange of correspondence.
But what you have here, and what I'm putting to you, is not my opinion. What I'm putting to you is the opinion of the Data Commissioner, what was in her report, and what she said to this committee. And what she said to this committee was that, of course, she was willing to meet at the appropriate time when she first got a response back. She had directed that there be an implementation plan. She felt it was appropriate that plan should be put in place, and then she would meet. And then she got a letter from yourself then to say that you wanted to meet, but at that point, if I can read directly from what she said, it was entirely inappropriate that we would engage in a meeting where we had issued finalised findings and clear directions. So at that point she had issued finalised findings. Isn't that correct? So she contends that at that point it would have been inappropriate for her to meet you. Well, and I would imagine that the CNAG would have a similar process when he does his reports. There's a process there where you allow an organisation to come back, but once you have a finalised report, would you at that point meet with an organisation once you finalise your report?
There usually wouldn't be any purpose to it. We would have had engagement, we would have meetings as we go. The important thing from my point of view is to get points in writing, because ultimately that's of an evidential value, and it would have to be from the accounting officer. I mean, certainly there have been occasions where a point might be discussed because of maybe a way it's picked up in media reports. That might happen, but that would be after publication of a report.
I think, Deputy, the Data Protection Commissioner's report was issued as a final report on the 15th of August. It came with a letter which accompanied it. From our perspective, we felt we needed clarifications on the actual meaning of some of the findings and on some of the directions which are given in the letter, because we felt there were some inconsistencies. We wanted to talk to the Data Protection Commissioner about that to get clarity on them. The Data Protection Commissioner, as you rightly say, felt that that would be inappropriate until she had an implementation plan, and then subsequently continued to feel it would be inappropriate. And that's entirely... I don't have a difficulty with that position of the Data Protection Commissioner.
No, but the Minister did have a difficulty with it, and the PQ suggested that the Data Commissioner, unfairly in my view, was not willing to meet. In fact, Ms McCrum, when she initially answered the question, said on that date in August that the Data Commissioner wasn't in a position to meet, but then put a caveat. Well, she was, that the Data Commissioner put a caveat that the implementation plan should be put in place. So my point is that there was a perception being put out there by the Department that the Data Commissioner was unwilling to engage with your department, when in fact she was willing to engage. But she had made it very clear that she had directed an implementation plan. It wasn't put in place. She wanted that put in place, then she would meet. But by the time you wrote to her, she had finalised her report and finalised her findings. And at that point she felt it was inappropriate. So it's important for the facts to be put out there. And it's important that there isn't a perception put out there by the Department that the Data Commissioner was unwilling to engage or unwilling to meet with the Department, when it doesn't seem to be that that was the case, that she was more than willing to engage.
I think, listen, Deputy, I think, listen, there's hair splitting, I think, to a certain extent going on here. The situation, and I'll repeat it, was we got a report which was a final report. There was no subsequent finalisation of the report. The final report was received on the 15th of August, together with a letter from the Data Protection Commissioner setting out the steps that the Data Protection Commission would like the Department to take. saying 1 week for this, 3 weeks for that, 6 weeks for an implementation plan. We identified issues in the report and in the letter, and we identified inconsistencies. We wanted to clarify those with the Data Protection Commissioner, and we wanted a meeting to do that, and we asked for an early meeting. The Data Protection Commissioner didn't feel that would be appropriate and told us so, and said, we'll meet with you when you've accepted our findings and delivered an implementation plan. Now, it'd be difficult for us to develop an implementation plan if we didn't accept the findings, and even if we did, it'd be difficult to develop an implementation plan where we felt there were inconsistencies and lack of clarity around some of the findings and the analysis. That's why we wanted a meeting. Now, the Data Protection Commissioner, and I don't object to this, the Data Protection Commissioner didn't feel that would be appropriate until we had an implementation plan. That's fully the Data Protection Commissioner's prerogative. There's no contention here.
I have one more question, but I need to just to make one point. The Data Commissioner was very clear that there's a difference as well between findings and rulings. The Data Commissioner makes rulings, and the Data Commissioner has statutory powers. And I think one of the points she made is that there is an increasing or a growing awareness among some departments about the role of the Data Commissioner's office, which isn't an advisory one, that there are enforcement pieces to it as well. But I just want one more question, if I can, in relation to the report, because it relates to the CNAG's report. And it says, it's paragraph 43 of her report, where it says the CNAG report in 2015, which I think you referenced earlier in the day, Cathaoirleach noted that the accounting officer of the department was of the view, and I quote, while a business case had not been developed, the project has been coherently planned and implemented in conjunction with DEPR and with the support of relevant decision makers and stakeholders. It goes on to say that the Data Commissioner was of the view that the PEC was more piecemeal and less coherent than suggested. And then it says, I just want to get your view on this, because it obviously came from either yourself or from your department. The DPC notes the Department's objections to the DPC's description in this regard, that it was piecemeal and less coherent. Firstly, on the basis that it represents, and I quote, a collateral undermining of the Controller and Auditor General's view of the PSC project. What did you mean by that?
I think it's clear, Deputy.
Well, maybe make it a bit clearer for me.
Well, Deputy, I think the DPC in its preliminary report referred to the Controller General's Auditor General's report from 2010 and noted, I think, that or 2016, and noted that the Controller and Auditor General had said, notwithstanding there was no business case, 17 out of 19 elements were best practice, and there is evidence that it was coherently planned. And I'm paraphrasing here, and Seamus might correct me if I'm wrong on that.
And I'll get to Seamus in a second.
The point is that, let me finish. The point is that the Data Protection Commissioner then went on the preliminary report to say that maybe, it wasn't as coherent as the Controller and Auditor General's report suggested. We think that that was an unnecessary observation. Yes,
but what you said was, and I quote, collateral undermining. And collateral, in layman's terms, also would be substantial. Fairly so. It's a collateral undermining of the Controller and Auditor General's view of the PSC project. Would that be your view, Mr McCarthy?
I don't believe that the Data Protection Commissioner's points undermine my report. It wasn't commenting directly on whether my report was reliable or not. I think there's a little bit of quoting out of context here. Just to be clear, in the report in 2016, I did go through, or at least the team went through the process of looking at the elements that should be in a good business case. It was looking at documents that were compiled between 2003 and 2011, and we found that there were a lot of elements there, but there were some key ones that were missing. I don't think it would be fair to characterise what we presented in the report as saying, well, that's as good as a business case. It isn't. And I think the conclusions of my report in relation to that explain what a good business case is. But I do refer to the fact that the accounting officer was of the view that it wasn't possible to build a single detailed business case, and that while it hadn't been developed, the project has been coherently planned and implemented. So I think it's the accounting officer's view, actually, that the Data Protection Commissioner was challenging, not mine.
Yes, and I just wanted just that point to be clear, and I'll finish then, because it is an important point, because the Data Commissioner made reference to this as well, is that the department's response back to the Data Commissioner at that point was that it represented a collateral undermining of your PSE report. And just so we're clear, that would not be your view.
No.